morning, everyone. We're just waiting for a couple more people to pop in from the waiting room. Okay, let's go ahead and get started. Welcome to our Wednesday Q&A. We're going to start out as we normally do with our Zoom housekeeping tips. You'll find your mute, unmute, stop video, start video, probably at the bottom of your screen, depending on what device you're using. We ask that everyone stay muted during this presentation to reduce background noise so everyone can hear. If you have a question, and we're likely to have time at the end, so please feel free to drop questions into the chat. And that's another thing, the chat is not legal advice. This Q&A is not legal advice. If you have questions based on your specific documents or your specific situation, you need to contact your association attorney. The chat is not for conversation like you see on the CAI message boards. So please don't use that for that purpose. It's to ask for clarification or just drop a question in. Moving on, this is our usual comment on the Corporate Transparency Act. It's still being challenged by the National CAI. And we recommend waiting until later this year, probably in October or so, to start looking at whether or not you need to comply. One thing we do want to add is that CAI put out a call for action so that owners and managers can contact your legislative person in Congress. There is a bill in the House to exempt community associations from the CTA. So if you haven't already, please contact your legislator in Congress, the national level, not the state level, and ask for them to support that bill. So also the 2024 changes to WUCIOA and other statutes are now showing on the legislative website. So if you Google or whatever platform you prefer using, RCW 6434, 6432, whatever your applicable statute is, the language on the website, the legislative website that comes up will be the accurate language right now. There is no Q&A next week, August 14th. We hope everyone enjoys their week. This is a quick reminder that CA Day is coming up on October 5th. If you haven't already marked that time off on your calendar, please do. It's a fantastic fantastic resource for managers and boards. There's educational programs going on. There's a really big trade show with vendors that only work with community associations or have a focus on community associations. So it's a really great time, and we will have a booth there. All of our attorneys attend at least some part of the day. So if you want to come in and join us and meet us in person, that would be fantastic. So like I said, we're likely to have time to answer questions today. So please feel free to drop a question into the chat. So starting with the questions that were submitted ahead of time. In addition to our monthly board meetings, which are open to all, our association conducts monthly workshops where we discuss issues in depth. Workshops are also open to all owners. We publish the schedule of some of these. We publish the schedule of these regular meetings annually, send notices to owners about a week in advance. The notices include an agenda for Board of Directors meetings and provide a list of discussion topics with notices of the workshops. They publish non-verbatim minutes of these meetings. From time to time, board members and or advisory committee members have occasion to meet to discuss or work on, but not vote on various issues. At these sessions, we might develop scopes of work, consider contractor bids, plan events, develop preliminary budgets, meet with a reserve study analyst to review and discuss reports, or discuss issues with our insurer. Is it necessary to make what are primarily discussions and information gathering sessions open to all owners? So the applicable statutes here are 6438-035 sub 4 and 6490-445 sub 2. And if you don't fall under these two particular statutes now, you will starting in January 1st of 2028. We highly recommend you start getting used to having open meetings. The legislative intent behind these statutes is that if a quorum of the board is meeting to discuss association business, it does not matter what you call it, it is a board meeting. Unless there is an exception allowed for executive sessions, all board discussions and information gathering must happen at an open meeting. Advisory committees don't have the same requirements, but the legislature could change that at any time. Now, the reason why the legislature this is such a hot button for the legislature right now is that they are listening to conspiracy theorists or other individuals who are absolutely certain that boards are doing things behind closed doors. And if you've listened to this Q&A anytime over the past, I want to say even 6 months, this question comes in very often. It seems like people, not necessarily the person who submitted this question, but boards and or managers are looking for ways to change the name of what essentially is a board meeting not necessarily to avoid open meeting requirements, but for whatever reason, they don't want to hold this meeting in an open session. And unless there is an exemption for the executive session topic, it must happen in an open meeting. Now, executive sessions are not separate meetings that the board can call whenever and call it an executive session. Executive sessions must happen during an open board meeting. The board votes to go into executive session to discuss business, and then a vote has to come out. The board has to come out back into open session and take a vote. Now, if the executive session is just to discuss bids or what have you, the vote doesn't have to happen. If you're not going to vote on that particular issue at that time, you don't have to come out and vote on that particular issue. But the going into and coming out of executive session must happen at an open meeting. There's very little way around this now. Any meeting of the board, which would mean anytime a quorum of the board is present to discuss or be informed of any association matter, would require minutes, and it is a board meeting. 6490 specifically states that you cannot use social gatherings as a means to evade open meeting requirements. So the legislature isn't going to change this anytime soon. If you've listened to this Q&A at any time over the past 6 months, year, what have you, you will hear this time and time again. A board meeting is a board meeting is a board meeting. It doesn't matter what you call it. It's still a board meeting. It should be open to all owners. And executive sessions happen during open board meetings. Ken, did you have anything to add to that?
Well, I would just say of the examples which the person with the question had provided, the only one I think could go into an executive session would be considering a contractor's bids, because that is, I would say, falls under the negotiating a contract provision of the exceptions which are allowed by the legislature. And, you know, we know a lot of clients that do things in closed sessions, which are not really specific in the statute, like talking about delinquencies. There's not a specific exclusion from being done in open session for delinquencies, but a lot of clients do it. And we think that's okay. But again, the decisions about how you handle the delinquencies have to be made in open session. And it is, a shift in how a lot of associations have functioned over many years. And it is an intentional shift by the legislature to make the conduct of the board open. And it may not be because of your board, but because of whatever, whoever went to the legislature and convinced them that boards are acting behind closed doors for their own self-interest, they got the legislation to change. So, anyway, the second question I'll offer actually came from me, and it's two parts, and it's because of a case that came out of the Division III Appellate Court last week. It was issued on Friday, and it is an unpublished opinion, but it had very specific things for homeowner associations that I thought were important. The first one is, the question is, can a member of an association sue an association under the Consumer Protection Act for what they consider to be inappropriate conduct? And the short answer to that is no, you cannot sue an association under the Consumer Protection Act, because it is not a organization which is advertising to the public. And the court was very clear about why the association was not applicable to the Consumer Protection Act, even though it was an association that provided water to their membership, and the water could be considered something that they are selling. And the second question is, could an HOA that provides water to its members terminate the service to a house without a court order? And there are a number of private homeowner associations with private water systems, and they still have to meet, quote, public water system standards for how they operate, but they are wholly owned by the association and managed and maintained by the association. And the homeowner association was having a problem with one owner who was using excessive amounts of water to water her driveway. She had a dirt driveway, and to keep the dust down, she was watering it. And the water was causing damage, and it was also something she was doing during a drought situation. And when one of their pumps was broken, and they were asking all the owners to cut down their water usage, and she refused to do it. So the association went out and terminated the water to her home. And so she sued, and the court held that the association had really broad powers and authority, and they could exercise those powers to terminate the water to her home if she was abusing her rights to use the water, and they didn't have to get a court order first. So it was a fairly, I think, a significant case in terms of clarifying rights of associations. I will note it is an unpublished opinion, which means that it's not something which the court felt so strongly about, but it could be published. The way the court system works is most decisions are unpublished first, and then there's a period of, I think, 30 days during which people can ask the court to publish it so that the court can reconsider how strongly they feel about the decision. So it's an interesting case. It's called Carey Tilley, Tilley versus Edelweiss Maintenance Commission. And you can find it online, I'm sure. Anything you want to add, Jennifer?
No. Moving on to our next question. Our condominium operates under 6434, at least until 2028. In reviewing 6434 372 sub 3, the records retention statute, I see several paragraphs specifically state certain types of records must be retained for at least 7 years. However, some paragraphs, such as sub K, do not set a time period. Should those records be kept indefinitely, and what should we do regarding them? So the record statutes are pretty much the same across the board. 6432 170, 6434 372, 6438 045, and 6490 495. Some records, specifically or typically board and annual meeting minutes, must be retained indefinitely. If the statute gives a retention period, like 7 years, at least some of the annual Secretary of State reports, the statute will say what the retention period is. It must be, the record must be retained for that retention period. If the statute is silent, that retention period might be indefinite. But one way to cut down on paper and some of the retention issues, you can always scan paper into PDF or some other file type, as long as the file is able to be recalled, retrieved, and maintained by the association. Statute discusses current records that must be updated continuously, like lists of owners, lists of board members, the declaration, insurance policies, etc. Prior versions of that record may not need to be retained. If you have a specific question on a specific type of record, contact your association attorney. The statute lists the permanent, which is always keep this copy, or like board meeting minutes. That is an indefinite record. One thing that we run into a lot, the statute sets the retention period for ballots as 1 year. Challenges to amendments cannot be made after a year has passed, so this would provide the ability to prove the vote results. We would often recommend ballots, even if kept electronically, be destroyed after the 1 year. So if the statute sets a retention schedule like 7 years, the prior documents can be deleted or gotten rid of after the retention schedule has passed. We recommend that associations regularly maintain and destroy records that do not need to be maintained. The reason being is that when you get a records request from an owner and you've maintained all of this information that doesn't necessarily need to be maintained, you still have to provide it, you still have to pull it. If it has passed the retention schedule, you can just get rid of it. You don't have to keep it. Ken, did you have anything to add to that?
Well, I'll just offer, there is still some confusion, and some records like notice of a meeting. I don't believe the statute says how long you save notice of a meeting. And that one seems to me where after a year or two, there's no value to it, but the statute doesn't specifically say we can throw it away. And that is a good example where I'd say we'll save it electronically, as Jennifer mentioned, and then probably at 7 years, it'd be safe to throw it away, because most of the documents that seem to relate to actions of the board, all the financial records, contract documents, they have a 7-year timeline. And I think it'd be safe to get rid of those notices after 7 years, very little risk. Next question. As a homeowner of a condo, I'm curious about what documents I am entitled to request. And this, of course, relates to exactly the same statutes which Jennifer just mentioned. So the statutes have lists of records that can be excluded from being given to a homeowner. But the short answer is basically anything not restricted by that list in the statute is available for review by the owners. But the association only has to provide records as they are kept in the course of business. They don't have to go through and find a specific document for you. So if you wanted a copy of every time an action related to noise was discussed by the board doesn't have to go through their minutes looking for it. They can just give you all of the board meeting minutes and let you go through and look for those dates where anything related to noise was discussed. And it's also important to remember that the association can charge owners for costs it incurs for record requests. So there's going to be a reasonableness factor applied to this because there is for all actions by associations. If you're asking for a copy of the financials, and we know that those are kept electronically and provided regularly to the board, I don't think that you could, I don't think an association could successfully charge an owner for giving them copies of the financials. On the other hand, if you're asking for records going back 15 years and they're in boxes in a basement or stored at Iron Mountain and the association incurs expenses, then those are expenses that can be passed on to the unit owner. If you are an association or manager, you should be telling owners in advance that costs are going to be incurred and give them an estimate of what those are, instead of providing documents and then surprising them with a bill. One of the things which came into WUCIOA in June is a much clearer mandate that before you can assess expenses to owners, you need to give them an opportunity to be heard. So that applies not just to fines now, it applies to expenses that are due to an owner's negligence. It applies to assessing the insurance deductible to an owner who causes damage. And so I think the same sort of concept that owners need to be informed and basically given a chance to discuss something with the board before they are assessed a charge would apply to charging for review of records. Anything you want to add, Jennifer?
This was a multi-part question, so I think you
Oh,
have a bit
well,
more.
then I get to keep going. All right. Second part, are management companies required to send you notice if your account is delinquent before forwarding it to an attorney? Okay, so I'll offer that the statutes do not require management companies to do anything. They may require your association to do something, but not the management company. And so whether there's a requirement is going to depend mostly on what your governing documents say. And so many are specific about what has to be done before an account goes to an attorney. Others are completely silent. And there are sometimes factors that might accelerate when it goes to an attorney. So for example, if a foreclosure notice was put on a house, the association might immediately send a file to an attorney rather than go through the process of 60 days notice before it goes to an attorney, because the rights of the association might be affected before that time. So there are statutory pre-foreclosure notices, which may be sent by the association or management company. But again, that may or may not happen before it goes to an attorney. Chelsea, can you just throw the list of statutes into the chat? And I don't have to read them all because people don't pay attention when we read the statutes anyway. So management companies are only going to do or be required to do what they are instructed to do by their board of directors. So if the board of directors adopts a policy that says that delinquency notices go out before it goes to an attorney, then those policies should be normally followed. And again, there's nothing mandatory in most CC&Rs, and there's certainly nothing mandatory in the statutes about what the management company does, though there may be with regard to what the association does. And I think the real question might be, is the association required to send notice before it goes to an attorney? And without review of your specific community documents, we cannot tell you. We can't give you an answer. But on the other hand, I would be surprised to have a collections account come into our office without there having been substantial efforts or repeated efforts by the association or the management company to communicate with the delinquent owner first. And then the last part of the question is, how can I find out if there's a lien on my condominium? So the answer is all liens are recorded with the county. So you can check with the county. Most of the counties now have a fairly easy ability to check records online. Certainly, King, Snohomish, and Pierce counties have it. And I believe, Skagit and Yakima County, and most of them are probably doing it now because it's fairly simple and easy. So you can search the county records by your name or your tax parcel number. You can also ask a title company to look it up, because the title companies can go through and search all of the records recorded against any individual condo unit or individual lot. Anything you want to add, Jennifer?
Just a quick note that the record is retained in the county where the property is. So if you have a condominium in Pierce County, but you reside in King County, the record will be in Pierce County regarding that particular piece of property. So the next question, what is the difference between a resolution and an amendment? And when should each be used? I have an association that wants to do a resolution to make sure owners have a minimum of $100,000 liability for because of an insurance carrier request for purposes of getting a renewal proposal. So a resolution is basically anything that the board votes on or does that's within their authority. So a motion that is passed at a board meeting is also a resolution. People use the word resolution to think it means something more formal when it's actually not. So adopting rules is normally within the authority of the board. The board can, by resolution or just voting at a board meeting, adopt rules. Requiring an owner to purchase insurance would likely not be within the rulemaking authority unless specifically provided for in the declaration, or CC&Rs is another word for declaration. Some declarations specifically state that the board can do that, but if the language is not there, probably not. If you have a question on whether or not your documents allow the board to do this, contact your association attorney. So there's also resolutions to add a board policy, resolution to start the process of getting a loan, form a committee, etc. So the board cannot do something by resolution that is not allowed by the declaration. So resolutions cannot restrict pets if that particular provision is not in the declaration, prohibit rentals, prohibit Airbnb, or change allocation of expenses, change voting rights, etc. Any rights and obligations of property owners cannot be done by resolution. An amendment is when the association formally makes a change to their governing documents. And this amendment is specifically used typically for the declaration and the bylaws. They typically require ownership approval, a specific percentage of ownership vote. So you have an amendment to adopt WUCIOA, and an amendment to allow deductible shifting, require owners to have insurance, a rental cap amendment. So normally we see insurance companies asking for the owners to have property insurance rather than liability insurance. Your attorney would need to review the documents and let you know what you can and can't do. But often we see boards trying to, and this question came up for me yesterday. We see boards trying to put in the rules that owners have to have insurance or owners are responsible for damage they cause, when that particular language is not present in their declaration. When there is a resolution or rule that doesn't have the underlying authority in the declaration, that resolution or rule is invalid and unenforceable. So if you have questions on what you can and can't do, please contact your association attorney. They can tell you based on your documents whether or not you can do something by resolution or whether or not you have to amend the declaration to do that. Ken, did you have anything to add to that?
Yeah, for some amendments, you also may need to have approval from mortgagees. Because most of the, especially condominium declarations written in the past 20+ years, have provisions to protect the lenders. And often there will be a laundry list of revisions which would require mortgagee approval or eligible mortgagee approval in order to be effective. And so it is helpful to have an attorney review your documents to make sure that if you are adopting an amendment, that it is within the authority of the association and doesn't require outside approval. There are sometimes even approvals required by the city or county where the property is located. It's not particularly common, but there are certainly documents I've gone through where the city of Kirkland or the city of Renton or the city of Mount Vernon has a special right that is in the recorded document that they have to approve any change to the document. Next question. We were short of questions, so we had a couple of our own, and this one is, will we have to amend our declaration or CC&Rs when WUCIOA applies to us on January 1st of 2028? And the answer is no, you don't have to amend the documents. And just as most homeowner associations did not amend their documents in 1995 when the HOA Act went into effect, you can just keep your documents unchanged. You just have to know what parts of the CC&Rs are invalid in order to comply with the new statute. But you don't need to actually amend the document. You might want to make up a sort of a cheat sheet to tell your board members and owners what parts of your document are overridden by the new statute. You could certainly adopt an amendment to say what the changes are, or you can adopt an entirely new document to reflect the current new requirements and remove all the conflicts. But you're not required to do any of those things. And it is important to note that when WUCIOA applies to you, whether you have adopted it early or you have waited until January 1st of 2028, there is a specific provision in WUCIOA to allow the board, without a vote of the owners, to amend the CC&Rs or declaration in order to remove actual conflicts between your documents and the statute. And so if you want to clean things up at that time, you can do it just by approval of the board following notice to the owners. Anything you want to add on that, Jennifer?
No. And the last question we've prepared ahead of time. So if you have any other questions, please feel free to put them in the chat. I see that we've already had a couple starts. So Chelsea, if you could get ready for those. So the last question is, how can I find out what parts of our declaration or CC&Rs are changed by WUCIOA? So there's no easy one place to go look except to go look at the statute and figure it out. So some are easy to find: the number of days for notice, your quorum size percentage required for amendments to the declarations, audit requirements, voting by secret ballot. Some may be more difficult to find, or your document may be silent regarding a topic such as records retention, how notice is provided, and requirements for opportunity to be heard before you can assess owners for some costs. You can do it yourself. You get what you pay for. If a board tries to do this themselves and they're wrong, you're on the hook for that liability. if you contact your association attorney and ask and get a list or amend your documents, that liability is passed on to the attorney doing the work. So remember that bylaws or even articles of incorporation may be affected by the statute change. Rules and policies will also have to be amended as well. An obligation to provide notice before the obligation to provide notice and opportunity to be heard before a fine is assessed to the owner, that's present in 6434, 6438, and 6490. The provision in 6434 also applies to old act condos. So knowing what specific statutes apply to your particular association is probably a question for your association attorney. We don't necessarily, it's a recommendation to contact your association attorney and ask. But if you don't, just know that you're taking on that risk yourself. And as Ken stated before, just this year, the legislature changed WUCIOA to added requirement for notice and opportunity to be heard before assessments can be made for damages caused by an owner. So as a board, instead of trying to keep up with what the legislature is doing, you can ask your association attorney to give you a rundown and go to CAI webinars or chats like this forum. You can be educated. If you have specific questions, we recommend contacting your association attorney. Ken, did you have anything to add to that?
Well, I think it might be prudent for associations to budget for some attorney assistance in figuring this out. We have a number of clients that are choosing to adopt WUCIOA early because there are provisions which are helpful to them. And it might be good to know if you should adopt it early. And we will try and have in the next month or two a flat fee option for us to review a particular association's governing documents and tell them what the changes are that they will have to comply with. I don't know what that number is yet, but we do think that that's something which would be valuable for a lot of our clients, and a lot of them want fixed flat fees they don't have to worry about. So we'll try and come up with one before everyone prepares their budget for next year. That's all I got. So I guess we go to questions from the chat.
All right, so first one, our community has some common area that is situated on a high bluff, which is susceptible to potential erosion, undercutting, and landslides. What is the best practice for warning signage? Are there any legal requirements regarding signage height or color, or for distance or roping between signs? Does the best practice change if the association hires a contractor to trim trees on the bluff?
So this starts to get really specific, and so I want to preface this by we're not giving legal advice in this. I would say the general rule is that the obligation to warn is really going to come down to how obvious the risk is. And so if the bluff is really obvious and people drive to your property to look at the view off the bluff, then the obligation to have signs is greatly reduced because the risk is obvious. If the risk is hidden, is when something like signs become important.
And even then, oh, I'm sorry, Ken.
Go ahead.
I'm just remembering a specific case that came through on the CAI lawyer listserv. And this has been a few years ago, where a particular owner decided that he wanted to go into common area to cut down some tall grass or something like that. And there were divots or there was something in the land under the vegetation where that particular owner fell and got injured by his equipment. And the court found that the association was not liable for that owner's injuries because he was doing something that, number one, he was told not to, had no authority to do. And the association wasn't liable because they didn't know what was under the ground either. So this gets to be really, really specific. So as Ken said, contact your association attorney, but in the case of a bluff, the danger is fairly obvious. But if you have specific questions regarding this, please contact your association attorney.
Yeah, so things like, a lake or open bodies of water are usually considered pretty obvious. And so, the signage, if you're being cautious, might be limited to, telling people not to swim, or telling people there is no lifeguard, or, no safety precautions being taken by the property owner. We've had clients who wanted to prohibit their owners going on to the open areas, and that's something which may not be possible to do given that the owners have rights under the CC&Rs to use of the open spaces. It would require some use or some review of the documents. I don't know how allowing someone to go and trim trees on the bluff would change any of the risk for the association. I'd certainly tell the tree company that there's a bluff there, and the tree company would be responsible for the safety of their own employees.
Next question, Chelsea.
All right, so next we have, is a ballot for proposed declaration amendments different than a ballot for a proposed declaration restatement? Do you recommend that the ballots have separate lines for each proposed change?
That's too specific for this forum because we would have to know. Typically, when we do an amendment, if it's a single amendment or a dual amendment, that means two purposes in one document. We would probably parse them out in a restatement. If there was a particular provision that would be controversial, or you want to have a separate owner vote, you can do that, but it really depends on the document. So you should really have your association attorney look at this. And just another caveat, we have boards wanting to amend their documents or do a restatement on their own to save money. I know we've covered this several times. It typically costs more in the long run to have us fix something that was done without knowing that it would cause problems than it would be to have us do it, have us or your association attorney do it right the first time.
So I guess my answer would be the difference between a ballot for an amendment and a restatement is just the label at the top. They perform and function the same way. With regard to the question about separating out topics, it certainly can be done. And we've had clients that have had, owners vote on whether or not there should be a prohibition on smoking or the rental cap, or whether or not they should limit animals. And sometimes they do that so that they feel like the owners are making informed decisions. Sometimes they do it because they think some parts of the document might fail and they don't want the people rejecting arbitration to cause the whole document to fail. So they'll have some items listed separately first, and then a catch-all for the whole rest of the document. But I had one client who asked me last week to make a ballot which had a single yes/no, that you either accepted the bylaws and the restatement as a combined package or you rejected it, because they felt like their membership was more likely to vote if there was only a single box to be checked. And that's okay. And we had a client a few years ago that needed 90% approval because of the rental cap they were adopting. And I had suggested that they vote separately on the rental approval because they only needed 67% for the rest of their document. But they wanted to present it to their membership as a single vote. And they did. And because they were so good at communicating with their owners, they had building captains and they had board members who were willing to go door to door. They were actually able to get the 90%. And it was with a single yes, no vote on the document. So it becomes a strategic kind of decision that the board has to make. How are you more likely to get the participation of your owners? How are you more likely to get the vote you want? It's certainly possible if you were voting on something controversial like limiting the number of pets and at the same time the rental restriction, if you voted on those separately, you might get the required percentage, even though different people voted yes and no on the two different topics. Anything else, Chelsea?
Yes. So next one. Do CC&Rs that apply to a unit that is part of an HOA property run with the land? Do they have to be attached to the title of individual standalone properties?
Well, the answer is absolutely they run with the land because they've been recorded with the county against the land. And when you ask, do they run with the title? You may mean deed. And because the deed just transfers ownership of the property, I guess the shorthand would be yes, they run with the title. Because they were applied to the property and do not terminate unless the CC&Rs have a termination provision in them, and some do.
I would point out that if you're just looking at a deed, it may not, a deed that's recorded with the county, it may not have every single document that's been recorded against that particular property. So one way to check would be to check with a title company. But typically, when you're looking at an association, if it's common property or if it's just some sort of parcel, the county in the legal description on the assessor's website should have some reference to the association if it's part of the association. If you have a specific question on a specific parcel, you can contact your association attorney. They generally know how to look this up. You can also contact a title company. They should be able to pull that for you.
Yeah, the title company's records are probably the ones that would be most accurate because they're providing insurance or will sell you insurance that says that they have uncovered every property restriction on a property. Chelsea?
All right, so next question. If the declaration states that the annual meeting shall be held the first quarter of the year, can the board reschedule towards the last quarter of the year together with their budget ratification meeting?
So can and should are two different questions. If they failed to hold it in the first quarter, I think that an owner could certainly come to them and object and demand that they hold it. And if a client came to us and said that had occurred, my advice would be just call the meeting. But we have a lot of clients that just forget to call the meeting or don't call it because they don't have their audit prepared. And there's generally not any harm caused by it. And there's also a remedy in that the owners can petition to call the meeting themselves. But certainly my preference would be to amend the document to provide flexibility so the board can call the annual meeting anytime they want, or amend it to combine the annual meeting with the budget ratification meeting Because probably when the document was written, there was not an obligation to ratify the budget. And so it's just a function of the document predating the modern requirements. Anything you want to add, Jennifer?
Just briefly, one of the things that we say quite often in our office is if you have a practice different from what your documents say, you can either change the document to fit your practice or change your practice to fit your document. So if you're doing something, as Ken said, if you're doing something that is different from what your documents allow, an owner can challenge it. How much risk you want to take on that particular issue is up to the board. But if you're going to do something that's different from your documents, please just change them. It makes things so much easier down the road. Chelsea?
All right, so next question is, does the mortgage company have to request to be notified for document changes that are being discussed? If not, have they waived the right?
So I would say that under WUCIOA and the Condominium Act, the answer is that the mortgage company must have made a request to the association. That makes them an eligible mortgagee. And the statutes, both of those two statutes, very clearly state that if a mortgagee's approval is required by a set of governing documents, only eligible mortgagees are required to be consulted. So that would be another reason you might want to adopt WUCIOA, is because if you're an old act condo or a homeowner association, which has requirements for mortgagee approval for a particular change you want to make, under WUCIOA, you only have to contact the ones who have asked to be eligible mortgagees. And right now we're finding in the industry that there are none. It's incredibly uncommon for a bank to have contacted an association to ask to be contacted when an amendment is made. Now, we are also careful not to amend documents to hurt mortgagees, because what we don't want is someone coming back and suing the association later because they couldn't recover on their mortgage. But we do try and make it so you don't have the hassle of contacting all of the lenders in order to make a change to the document. Anything to add, Jennifer?
No. Chelsea?
Does the Transparency Act apply to all nonprofit organization?
We're talking about the Corporate Transparency Act.
I believe so.
Okay, so does it apply to all nonprofits? No, it does not apply to all nonprofits, because the statute specifically exempts currently nonprofits which are under 501c4 of the IRS code. And 501c4 is organizations which are promoting the items for the benefit of a community. The problem is that the IRS has very specifically stated that homeowner associations do not qualify as 501c4. The only exception is a large community which provides services for the benefit of the public, not just their members. So it might be that a community the size of Klahani or Mill Creek, which has public parks, which the public, meaning people who are not residents of the association, can come and use, they might qualify as a 501c4 and get out of being required to use the Corporate Transparency Act filings. But otherwise, most associations are not. I'll offer, I have not researched other types of nonprofit corporations and whether or not they are required to comply with the Corporate Transparency Act, but my guess is they do.
So one thing about the Corporate Transparency Act is that it requires nonprofit corporations that are registered with their governing body, usually Secretary of State. So if you have specific questions about your particular organization, you really need to contact an attorney. As we said at the beginning of the session, the CAI is challenging Corporate Transparency Act for community associations, but other organizations are also challenging the statute as well. So if you have particular questions about your particular organization, please contact an attorney to take a look at that for you.
And there's a bill in Congress right now, which is, would modify the statute to exempt homeowner associations.
So
Chelsea?
All
Sorry.
right. Does the term CC&R include all governing documents, or is it more restrictive?
The term CC&R stands for covenants, conditions, and restrictions, and it is, I would say, specific to the recorded document, usually called a declaration of covenants, conditions, and restrictions. Sometimes it'll say covenants, conditions, restrictions, and easements, and it is one specific document.
I've seen covenant conditions, restrictions, and reservations. We typically use shorthand and call it declaration. Oftentimes we'll have homeowners, board members, sometimes even managers say bylaws to mean everything. So you really have to drill down and find out which document the person is actually referring to. Typically for us, we'll say declaration or CC&Rs.
Yeah, the declaration or CC&Rs are the property rights and obligations which flow with the land. The bylaws are the documents which govern how a group of people who happen to own that land make decisions and elect their leadership. And so the association of people is different than the property. The association of people files articles of incorporation with the Secretary of State, and they have bylaws to supplement the articles of incorporation. The landowner records the property restrictions or the CC&Rs with the county, and those flow with the land. And to the extent provided in the declaration, the board or the people get to make rules and regulations to clarify what the CC&Rs say. You have time for one last question if you got it, Chelsea.
All right. Follow up to single yes, no vote on ballot. If there's a single yes vote, is a single no vote required?
I don't understand the question, but they either check the yes box or the no box.
If I'm parsing this correctly, they're wondering if they could just have a single check for yes and then leave it blank. And you could do it that way. We don't recommend it because it means that when you're voting on something, if an owner doesn't send in a ballot, it means it counts as a no vote. So having a single checkbox for yes, you can do that, but all it does is encourage owners to not vote.
Yeah, I think I would rather know which owners have voted no, so I can go ask them why, rather than have them just fail to return a ballot because their only option was to vote yes. But I think that we're done for the day. Thank you everyone for joining us, and there is no Q&A next week, so we'll see everyone in 2 weeks. Thank you.
Thank you.